You're listening to Forward Faster, bite-sized insights for entrepreneurs.
Thanks for joining us. Today we have David Howe from Boylan Code, who is going to talk to us a little bit about the field of trademarks and copyright and what startups and entrepreneurs need to know to, I think, effectively protect themselves, but also get some of that foundational work done initially when they're thinking about what is the best name for my company, or how do I go about naming my product that's in a safe way as well. So David, thanks for joining us.
Sure.
What is the difference between copyright and trademark? Because I think they're used kind of universally, right?
Yeah, all the time. It's so common to see people get those two terms confused. Trademarks applies to something that you want people to associate with a particular producer or manufacturer. So obviously a Nike swoosh, when you see the swoosh on shoes, there's only one company that comes to mind, right?
Mm-hmm.
Or a Macintosh computer, when you see a computer that has an apple on the cover, you know that's made by Apple. A trademark, as I said, shows the source of goods or services. So, the arches from McDonald's. And the reason that those are important is because they generate a reaction or a sense in the customer or the public about what is the quality of services, or what's the quality of goods that I'm going to expect when I buy that thing. Like Starbucks, everybody knows when they see that green logo that's Starbucks, but also they associate, is that good coffee or bad coffee? Okay, and that's obviously subjective. So if you're a company, you want people to have a positive impression of your product, and that the best way they can do that is by generating a logo that they can market, that everybody, when they sees it, knows, oh, I love Nike shoes. Those are Nike shoes, so I love those. Or vice versa. Copyright is an entirely different beast altogether, even though there is some overlap in with them from a legal sense. But copyrights are intended to protect a particular work of art, or a work of music, or a book, or movies, things like that, so that if I create something, let's say it's a book, I own the copyright in that particular book. Somebody sees the name of that book or sees what that book is, they know that it belongs to somebody. Somebody created it. They don't necessarily associate with HarperCollins Publishing, for example. If I see a Harry Potter book, they don't know who the publisher is necessarily, but they know that somebody wrote that. J.K. Rowling wrote that book. And so if you are buying something, then you have an implicit understanding that whoever created that is getting compensated for that work. And vice versa. If you're the creator of that work, you have an expectation that when you put something out there, you own the right to distribute it, to sell it, to profit from your efforts. And that's what copyright's really all about. It's not about who's selling it to you or who necessarily, but it's about who created it and who deserves the right to be compensated for the effort.
Well, that is a great explanation, and I think you had talked earlier in our Lunch and Learn about the concept of IP being an asset for a company, and so it's natural that you would want to protect that. What are some of the types of things that startups and entrepreneurs are trademarking the most? You mentioned, if it's an actual product, but what else would we be looking at to trademark beyond a logo?
Any startup needs to, or any company really needs to think about what it is that they create, that they sell, that they think has value to them. And sometimes that value may not always be obvious, but the obvious examples, of course, are products that they sell. But it's not just the product they sell, but characteristics of that product. What product lines could that product lead to? things like that. What logos might be associated with those products. And logos change over time. And so you need to be thinking about strategy of what is your portfolio of what is your family of products, and how does that relate to you as a company in the current day, but also going forward. What does that asset play in your strategic plan going forward?
Okay, great advice. And in terms of the different kinds of trademarks there are, I understand that there's several of them. Can you explain what the difference between those are, and what is the most basic thing that an entrepreneur can do today to start protecting their intellectual property?
Sure. So I'll answer that last part first, which is always use the little TM superscript next to a product that you are selling. That puts the world on notice that you are claiming that trademark to be your own for that particular product. What you can be doing is be thinking about to protect yourself is distinctiveness. Am I selling something that I'm calling XYZ something that is distinctive in some way? So don't create a product and don't sell a product under a name that is literally describing the product. Okay, if I'm selling a brand new type of noise canceling headphones, then try not to include noise canceling headphones in the trademark portion of that name. It obviously describes the product, so you want to be coming up with something else altogether.
So a good example is, I think you used this before, not to use pizza in your name if you're serving pizza. And when you do that, what does it do? Does it open it up to more scrutiny, more cost in terms of trying to figure out if it's something that you can actually get trademarked? What would be the negative side of that?
Sure. So you want to have in a perfect world to have the strongest trademark you can, and strength in the trademark world means distinctiveness. So if you were just calling your restaurant pizza shop, or if you have a bookstore, you're calling it bookstore, then obviously, you're the world that the world of competitors is everybody who is doing that. But if you call yourself Panda Express and you're selling Chinese fast food, then you're creating a niche name for yourself. When people say I'm eating at Panda Express, you have an association of the quality of the food there, and you either like it or you don't like it. But you can't dispute that it's a strong mark, because people, you want people to associate that with a particular producer or manufacturer.
Okay. And in terms of resources, is there a website or books on the topic of trademark and copyright that you would recommend people seek out to find out a little bit more information and get started?
Sure. So I think that, and I mentioned this earlier, but copyright.gov, if you're interested in copyrights, is a great place to start to learn about copyrights, what copyrights are all about, what type of protection copyright offers to you, and what type of thing that you need to do to file your copyrights. For trademarks, that's a tougher answer, a harder question to answer, because the easiest thing for me to say is to look on the internet or go to the library or go to the bookstore and find some book resources on trademarks. And I think for the most part, you're going to find some pretty good basic understanding of how trademarks work, what trademarks are. But ultimately, you're going to need to speak with a professional if you really care about protecting your trademark and what you need to do, what types of things you can do to protect your trademark, because obviously you can never always 100% trust what the internet says, and books are fixed forms of information, and the law is always changing, especially in the world of copyright, but trademarks also. And so what you may find on the internet on a given day either may be incorrect or outdated, and the same goes for books. And so the best way is to understand it is to have a conversation with a trademark attorney to figure out what it is that you're trying to protect and how to protect it best.
And in order to initiate that protection, I know you've spoken about it's great when the entrepreneur comes to a firm such as yourself to seek legal advice, that they do some homework up front, that they come to you with a brief, and that the brief includes some of the basic research around what is out there already, what is the competition doing, how does your logo or your mark or your product name stack up against the competition. Are there other things that they should be thinking about in terms of compiling into that brief to be most effective for you to start a proper engagement?
Yeah, I think that the best way to provide information to us is to an attorney is to be able to, your attorney is not going to always have a full understanding of what your product is and its place in the market and how it works or things like that. Especially for startup companies, and from the people I've spoken with today, they're working on a lot of very niche products that have a very nuanced role in what they do, and so being able to describe your product in a layman way to your attorney and to come with concrete examples of either to bring your product with you if that's possible, or to bring materials that would illustrate or to demonstrate how your product works is really important for the client to do when they come to speak with an attorney. Because then when a client comes to me with that information, I have I know what questions to ask. In terms of its role in the marketplace, what your competitors are doing, how long have you been doing this, where did the idea for this come from? All those things are necessary questions that build upon and are dependent upon my understanding of what it is you're coming to me with. Because if I don't have an understanding of what you're doing, what you're making, or what your service is, then it is a little bit harder for us to craft a trademark application that fits what you're doing, because we also there's also a conversation that takes place of based on not just what the product is and how you came to it and what it does, but also what you intend to do with it in the future. How the trademark itself or the product itself could expand into other markets, because while you can always file a trademark application for those other things later, if it's possible to file that trademark application that includes those things now, what you're doing is you are establishing priority of use for yourself at the get-go.
I think that's really good advice. And speaking from a marketing standpoint, we always encourage entrepreneurs to think longer-term strategy of how they're going to build out their product line. Mm-hmm. And a lot of times they don't want to go there yet because they're still iterating on the first. But I think that's so important to start to think about, how can I protect myself long-term in the marketplace? I was going to ask you a question like, what's the most common mistake? But I want to go back to something that you said earlier today when we were talking around those that contribute to the IP of the company or to the creation of a design, even around the logo mark. How should companies protect themselves when they're working with independent contractors or those that are contributing, even employees, into that intellectual property? What should they be creating and having those employees sign?
Sure. So employees ideally should have employment contracts that cover ownership of intellectual property, whether it's patents or trademarks or copyrights, especially those employees that are in that space that serve that role for a company. Those are, and you can still be an at-will employee and still have a contract that says you're an at-will employee. So you're just setting forth additional terms that protect the employer. So you can still have those protections, and certainly we always encourage that. And the same kind of goes for independent contractors. You need to have a contract that says that these people are independent contractors, that the work product, the intellectual property rights to that work product belongs to the client, and that if there are a lot of other terms that we include in these contracts. So it could be everything from, it could include terms such as that they recognize that everything that they're creating, we own the copyright. We are the author of those for legal purposes, or to the extent that we're not, that you agree to assign those rights to us. So there are various contractual provisions that we can always include with your independent contractors to make sure that you're protected in claiming ownership of it.
Perfect. Now, in terms of let's talk a little bit about future thinking. So maybe 5 years out, fast forward in the industry, where do you think law is going as it relates to intellectual property? Are we going to see maybe perhaps the government be a little bit more heavy-handed and place additional restrictions? Are we seeing things lighten up? I mean, what's your take on that?
That's an interesting question. I think that for the most part, in the world of trademarks, I don't really see a whole lot of change. I mean, there are always some new things coming up, but the body of law is pretty well established, and there are always going to be some interesting cases that kind of push some boundaries. So, for example, one of the current controversies that are in the courts deals with sort of the intersection of free speech and trademarks. So, can you have a trademark that is that some people might consider to be obscene, either with a swear word, or on the flip side, that's the actual controversy. But there have been other controversies of whether or not a trademark can a trademark be registered if it is something that is derogatory, ethnically derogatory, for example. So those are things that either have been recently addressed or are working their way through the courts. Those will, it's not going to turn trademark law on its head or anything like that, but they will be interesting developments in sort of whether we see it as an expansion of trademark rights or how they interact with other existing rights like free speech and stuff like that. In the world of patents, in the world of copyrights, I think that you're going to see a lot of changes, and I have no idea where they will go, but they're going to be largely impacted by the pace of technology.
Is that because access to some of those assets is becoming so much more open, or reuse so. is happening at such a fast pace that it's hard to kind of track?
Yeah, all of those things. The advent of technology and things like and streaming platforms, for example, and just the technological advances in how we create things. Makes everybody a creator. It used to be, as recently as 10 years ago, or even more recent than that. Artists were artists, right? It's a vocational category of who's an artist. An artist is somebody who creates music, writes, creates artwork, makes movies. Those are artists, right? And we, on the other hand, are non-artists. We're professionals, or we have other real job. Not real jobs, but we have other jobs,
yeah,
right?
A lot of people don't think lawyers are artists.
Right, exactly. But now anybody can, take their cell phone and create a 5-second video and post it on Instagram or Facebook or wherever, and suddenly you're a creator, and that can lead into an actual job. And many people are quite successful at doing that. But the question from a legal standpoint is, who owns the right to that? How do you enforce those rights, especially when things are so transitory, like a 5-second video that disappears on your Instagram feed, things like that. Those are kind of interesting questions that I think the problem is that all laws, but especially laws like in the world of copyright, they lag technology, right? They lag the pace of our society. And so how do you apply potentially outdated laws or outdated concepts to new things? Because the people who wrote these laws certainly weren't envisioning, somebody making an Instagram feed, and how do you protect that? Or how do you protect YouTube videos that incorporate music from existing works? There's a pretty famous one of, I think somebody was shooting some home video of theirs, some candid home video of theirs, and they had Prince the music from Prince in the background. is that worthy of a copyright strike from YouTube? So there's always challenges of how do you mold laws to make things fair for everybody. Is that reasonable? Is that unreasonable? I don't know.
Sounds like you're going to have a lot of challenges ahead. I'll give you a final question. If you have to describe what you do every day in this industry around trademarks and copyright, what 3 words would you use to describe that?
I can only give you maybe 2 words.
Okay.
But they capture what I do. Maybe 3 words. Advise, consult, and litigate. Those are probably the 3 words. I'm a litigator, so I don't just handle paperwork and do filings for clients. I also take matters to court if there's infringement and stuff like that. But I think the biggest part of what I like to think of in terms of what I do is advising clients, giving them guidance, giving them counseling on what they're trying to do so that they can make the best decisions for themselves on protecting their rights.
Well, that would be number 1, I think, in the startup realm, is to make sure that they're getting advice legally to protect that business that they're putting their heart and soul into and crafting every day. So I thank you so much for taking time with us,
Sure.
and hope to see you back soon.
It was my pleasure.
Thanks, David.
Thank you.